Okay, defendant's rights, page 109, 109. The rights of the accused of a crime. The Bill of Rights contains only 45 words that guarantee the freedoms of religion, speech, press, and assembly. Most of the remaining words concern the rights of people accused of crimes. That's a test question, I believe. Most of the Bill of Rights pertains to people accused of crimes. Now remember, it would have started out only national, federal crimes until it was incorporated to apply to state law and state action as well. The founders intended these rights to protect the accused in political arrests and trials. The British abuse of colonial political leaders was still fresh in the memory of American citizens. Today, the court applies the protections in the 4th, 5th, 6th, 7th, and 8th Amendments, mostly in criminal justice cases. And we say political arrests, the fear is if the government has power and the government is naturally full of people who have partisan views and political interests, they will use the power and the authority of criminal law against their enemies. Got it? It is useful to think of the criminal justice system as a funnel. Note the funnel part here. That is where there's a study guide question about the creating a funnel. This is it right here. Following a crime, there is sometimes an arrest, which is followed by a prosecution, which is followed by a trial, which usually results in a verdict of not guilty or guilty. The funnel gets smaller and smaller. For example, the ratio of crimes reported to arrests made is about 5-1. At each stage of the process, the Constitution protects the rights of the accused. The language of the Bill of Rights comes from the late 1700s and is often vague. For example, just how speedy is a speedy trial? How cruel and unusual does a punishment have to be in order to violate the Eighth Amendment? The courts continually must rule on the constitutionality of actions by police, prosecutors, judges, and legislatures, actions that a citizen or group could claim violate certain rights. Defendants' rights, just like those rights protected by the First Amendment, are not clearly defined in the Bill of Rights. One thing is clear, however, the Supreme Court's decisions have extended specific provisions of the Bill of Rights, one by one, selective incorporation, to the states as part of the general process of incorporation we discussed earlier. Virtually all the rights we discuss in the following sections affect the actions of both national and state authorities. Incorporation is especially important because most cases involving defendants' rights originate in the states. Because most criminal law is state law and state prosecution, it's going to be dealing with your rights, defendants' rights pertaining to state action. Police can not arrest a citizen without reason. At least they can't legally. Before making an arrest, police need what the courts call probable cause, reasonable grounds to believe that someone is guilty of a crime. Why do they need something? Because countries of tyranny, you can just be picked up by a van or a door gets knocked on by the KGB and you're never heard of again. That is what we're trying to protect against. So when you think, well, what's the big deal? You know someone's guilty. Or what's the big deal? I know he did it. It's about protecting the innocent and everyone that we give rights to the defendants. We have to have probable cause. They have to know what they're accused of, etc., so that we don't turn into a system of tyranny, which does happen in countries like North Korea, the former Soviet Union, current Russia, etc. Although you don't have to do it the way we do it. The European countries have a lot of these rules as well, but they might not have it in a constitution with judicial review the way we do. It's just done differently, but it's the same idea. Police often need to get physical evidence, a car thief's fingerprints, a snatched purse to use in court. To prevent the abuse of police power, the Fourth Amendment forbids unreasonable search and seizure. It requires police to meet certain conditions. A search can occur if a court has issued a search warrant. Courts can issue a warrant only if there is probable cause to believe that crime has occurred or is about to occur. A warrant, which must be in writing, has to specify the area to be searched and the material sought in the police search. A search can take place without a warrant, as most do, if probable cause of a crime exists. If the search is necessary to protect an officer's safety, if the search is limited to material relevant to a suspected crime or within the suspect's immediate control, or if there is a need to prevent the imminent destruction of evidence. The Supreme Court has also held that police may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with serious injury. The police can also use evidence after an illegal stop of a person if they conducted their search after learning that the person had a valid outstanding arrest warrant that was unconnected to the conduct that prompted the stop. Why do we know all of this? Someone appealed their court case and the Supreme Court granted cert. Remember what that is. Supreme Court granted cert. They thought it was a big enough issue, or the circuit conflict, or some other reason, probably, interesting case, big enough modern issue. That's why we know these specifics. So you all know what granting certiorari is. You all know that the Supreme Court picks its own cases and tries to make in their decisions change the interpretation, possibly change the interpretation of conduct or law. And here's a huge list of them. Okay, so these are all court cases, decisions. Aerial searches to secure key evidence in cases involving marijuana growing and environmental violations. That was a plane going across, and when planes cross over land and don't hover, anybody can look down with a camera and see it, so we don't need a search warrant for that, because I can be on a plane and see what you're growing out in public. The aerial. So we don't know about drones, though, because drones hover. Wait and see what a court case test says about that. Breath tests, motorists, roadside checkpoints, which police randomly examine drivers for signs of intoxication. Use of narcotic detecting drugs at a routine stop for speeding. But we also know from a court case that they can't seize you, search and seizure. They cannot seize you and hold you waiting for a drug dog without legitimate probable cause. Because someone did that. They made them wait 20 minutes, and then the cop argued it was because there was one of those tree air fresheners, and that meant he must, smoke weed or something. So I needed a drug detecting dog, and they seized the driver in the car, and that was considered an unreasonable seizure and consequently search. Dog is with them, that's different. Okay, the search of a passenger in car following a routine check of the car's registration. Hot pursuit of criminal suspects. Car stops and stop and frisk encounters with passengers and pedestrians when they are based on reasonable suspicion of criminal activity rather than the higher standard of probable cause. Of course, then there's an argument, what is reasonable suspicion and who is deemed reasonably suspicious by cops. That gets argued in courts as well as in the public. Mandatory drug testing of those in a safety-sensitive positions and high school athletes, even those who are not suspected of using drugs. So drug tests, the use of drug tests in sports, high school sports changes depending on the district. I assume depending on the state as well. But they have a right, the schools have a right to test you for drugs for a high school athletics, even if you're not showing any evidence of needing to be. The search of K-12 students with only a reasonable chance of finding evidence of wrongdoing rather than probable cause. It's much easier to search a student or because of the risk to other students and their right to an education. Strip searching anyone arrested for any offense before admitting them to jails, even if the officials do not suspect the presence of contraband. Okay, so there was a strip search case for students, a 13-year-old girl, I believe, down to her underwear over ibuprofen. That one they said was too much. The Supreme Court ruled in favor of the student. I'll probably bring this case up in class. However, there's another case a few years ago, but recent, where a man unfortunately was not supposed to be arrested. His warrant he didn't really have a warrant anymore out for him, but he had a body search, a body cavity search that they ruled, sorry, they have a right to do that. We'll talk about that in class too. But all these end up in the Supreme Court. Taking and analyzing a cheek swab of an arrestee's DNA is like fingerprinting and photographing a legitimate police booking procedure. However, some decisions have offered more protection against searches. Courts held may not search a car if there is no threat to their safety, although they may order a driver and passengers out of a car while issuing a traffic citation and may search for weapons to protect themselves from danger. They don't have just a right to search your car unless you give consent. Once you give consent, it's over. We can talk about that in class. Use highway checkpoints designated to detect ordinary criminal wrongdoing, such as possessing illegal drugs. So they can do highway checkpoints for being intoxicated while driving, stop you for test you for alcohol, but not just for any illegal activity. Without a warrant. Stop and frisk a person on the basis of an anonymous tip that the person is carrying a gun. Not anonymous. Use a thermal imaging device to detect abnormal heat needed for growing marijuana in a home. That was a case. They checked the basement. We'll talk about that. Use a thermal imaging Install a GPS device on a target's vehicle and use that device to monitor the vehicle's movements without a search warrant. Big case there. Search a cell phone without a warrant in most circumstances. Extend a traffic stop in order to conduct a dog sniff for drugs absent reasonable suspicion. That's the one I'm talked about. It was too long of a seizure. If the dog had been with the cop, it would have been okay. Test the blood of motorists without a warrant. It should be pretty easy to get a warrant if you need to test the blood, but you need a warrant. Inspect hotel and motel guest registries without permission from a judge. Search a vehicle incident to an arrest unless it is reasonable to believe the arrestee might access the vehicle at the time of the search to obtain a weapon, destroy evidence, for example, or that the vehicle contains evidence of the specific offense of an arrest. They cannot search vehicles for evidence of other crimes. Now, keep in mind, for all of it, once there's a warrant and they follow the warrant, all's good. Most of all of this has to do when they don't have a warrant. It's what they're allowed to search, and it's easier to get a warrant, easier than in the past where you had to go find the judge. Now you can do it electronically. There's an expectation that you need to get a warrant. What happens if evidence used in court was obtained through unreasonable search and seizure? In a 1914 decision, the Supreme Court established the exclusionary rule, which prevents prosecutors from introducing illegally seized evidence in court. Decades later, the Cleveland police broke into Doree Mapp's home, this is a woman, looking for a suspected bombing fugitive. While there, they searched it and found a cache of obscene materials. They wanted to get her, so to speak. They wanted to prosecute her for something. That's why they went over the prosecutor for obscene material, pornography. Mapp was convicted of possessing them. She appealed her case to the federal courts, claiming that since the police had no probable cause to search for obscene materials, the evidence should not have been used against her. In an important decision, Mapp v. Ohio, the Supreme Court ruled that the evidence had been seized illegally and reversed Mapp's conviction. Since then, the exclusionary rule, treated as part of the Fourth Amendment, has been incorporated within the rights that restrict the states as well as the federal government. Another example, Gideon's as well as Mapp. Michigan already had an exclusionary rule. So this Mapp v. Ohio, I don't know the specifics enough. I don't have a law degree in this, but I don't think it really applied that much to Michigan because we already had it. Just like Michigan was already supplying lawyers to everybody, counsel to the accused. So Gideon v. Wainwright was not relevant to Michigan. A state can always give people more rights. The Constitution and the Supreme Court are just the bare minimum. The state can't contradict Supreme Court rulings on the Constitution, but it can always give more. It can always go farther. Keep that in mind. Critics of the exclusionary rule, including some Supreme Court justices, argue that its strict application may permit guilty persons to go free because of a police carelessness or innocent errors. The guilty, they say, should not go free because of a technicality. Supporters of the exclusionary rule respond that the Constitution is not a technicality and that because everyone is presumed innocent until proven guilty, defendants' rights protect the accused, not the guilty. You can example one search and seizure case in the cases of Ms. Matoya, which follows next. Since the 80s, the Supreme Court has made some exceptions to the exclusionary rule, including allowing the use of illegally obtained evidence when this evidence leads police to a discovery that they eventually would have made without it. You can see where there's a lot of gray in there. The justices also have decided to establish a good faith exception to the rule. Evidence can be used in court if the police who seized it mistakenly thought they were operating under a constitutionally valid warrant or reasonably thought they were following the law. In 1995, the court held that the exclusionary rule does not bar evidence obtained illegally as a result of clerical errors. So the warrant is wrong or has the wrong address or something. In 2006, it held that a police failure to abide by the rule requiring them to knock and announce themselves before entering a home was not a justification for suppressing the evidence they found upon entry with a warrant. Now, I don't know what this rule is. It's not right with the Breonna Taylor case, no knock warrants. That's Indiana has a no knock warrants. You could just barge in. I don't know what Michigan's law is on no knock warrants, but it's a good example here that what the court rules versus what the state law is, and it needs to be looked at. The court has even allowed evidence illegally obtained from a banker to be used to convict one of his customers. In a 2009 decision, Herring v. U.S., the court held that the exclusionary rule does not apply when there is isolated police negligence rather than systematic error or reckless disregard of constitutional requirements. And you can imagine the controversies on all of this and police behavior. But also because, again, just because the court rules that it's not unconstitutional for any given behavior doesn't mean the states can't make laws about it. Okay. Please read, I guess I will read it. The War on Terrorism. The USA Patriot Act passed just 6 weeks after September 11th, 2001. Terrorist attacks gave the government broad new powers to engage in wiretapping and surveillance when investigating terrorism suspects. This was a big deal. To those like libertarians, it's still a really big deal. Even if you don't hear about it a lot, it's still an issue. Attorney General John Ashcroft also eased restrictions on domestic spying in counterterrorism operations, allowing agents to monitor political or religious groups, in this case, of course, it would be Muslims, without any connection to a criminal investigation. The Patriot Act gave the federal government the power to examine a terrorist suspect's record held by third parties, such as doctors. Libraries were a big one because librarians fought this. Bookstores, universities, and internet service providers. It also allowed the government to search private property without probable cause and without notifying the owner until after the search had been executed, limiting the owner's opportunities to challenge the search. Congress reauthorized the law in 2006 with few changes. Without the court-approved warrants ordinarily required for domestic spying in our country, George W. in 2001 ordered the National Security Agency, NSA, to monitor the international telephone calls and email messages of people inside the U.S. 2008, Congress overhauled the nation's surveillance law, the Foreign Intelligence Surveillance Act, FISA, allowing officials to use broad warrants, so just generic, so to speak, not specific to a person, to eavesdrop on large groups of foreign suspects, and ending the requirement that officials obtain a warrant for each individual suspect, as long as they wiretapped only communications to and from foreigners that happen to pass through American telecommunications switches. In order to wiretap Americans, however, officials must obtain individual warrants from the special FISA court. Although in an emergency, they are permitted to wiretap an American suspect for up to 7 days without a court order. The NSA tracked Americans' calls using numbers that had not been vetted in accordance with court order procedures. Intelligence court judges ruled that under the, quote, special needs doctrine, the NSA's collection and examination of Americans' communications data to track possible terrorists does not violate the Fourth Amendment. The NSA also collected and stored all phone records of American citizens and tracked their use of the internet and their financial transactions. President Obama has proposed ending the systematic collection of data about Americans calling, storing the bulk records at phone companies, inquiring the NSA to receive judicial permission before obtaining specific records. I don't know if they've stopped any of this. This is where Snowden, who is now in Russia, this is what he released information about, and claiming that he's sharing what's going on here. He worked for a private company. Remember that the federal government does private contracts, so it might look like the federal government's smaller, but really they're not, because they're contracting out. This is from the bureaucracy section. Well, they contract out some of our national security as well. And Snowden, Edward Snowden, I believe, was in the private contract company and gave up some information publicly in order to get attention to how he would argue. And it's been a while, so I don't remember the specifics. It's on Wikipedia, I'm sure, that this was happening to American citizens. American citizens were being spied on. And whether or not you care about that, it is still an ongoing issue. Go from there. So I'm going to stop it here and move on to self-incrimination next.